In today's video, I want to take a look at something that I come across very, very frequently on a daily and certainly on a weekly basis, but even on a daily basis. I meet employees all the time who complain about stress at work and being stressed. And wondering, is there anything that they can do about it, or what is the legal position? When they refer to stress, they are essentially talking about situations like disciplinary procedures. Perhaps they're involved in an investigation about a complaint against them, or indeed a complaint they have made against somebody else, against a colleague. Perhaps they've been placed on a performance improvement plan. Perhaps there's a risk that they're going to fail the probation. Also, they could be feeling stress as a result of the workload, or they could be feeling stress as a result of not getting a pay rise, which they may have factored into their external finances. They may not have got a bonus. There's any number of reasons. They may have interpersonal differences with the manager, or indeed with a colleague or a number of colleagues. Bottom line is, there's any number of reasons as to why a person may be suffering from occupational stress. But you need to be absolutely clear that occupational stress and actionable workplace stress are two entirely different things. Occupational stress is recognised by the courts as being present in the workplace and is something that you simply have to deal with. It's part and parcel of work. It's stress that's attendant with work, because work is not recreation, it's not play, it's not games, it's not fun. There is some stress involved in it, and discharging your duties, no matter what your job is, whether you're a cleaner or you're working in a coffee shop or working in a retail environment, or you're a doctor or a lawyer or an accountant. Clearly there's stress involved in all of these jobs. But that type of stress isn't enough to ground a successful claim, successful legal claim. A legal claim is going to be actionable if it is genuine workplace stress and it fulfills some basic legal principles that have been set down or accepted here by the Supreme Court in a case involving Berber versus Dunn Stores. In that case, in that Supreme Court case, which has been affirmed and recognised and used again and again as an authority for the propositions in it. In that case, the Supreme Court accepted and agreed the principles from an English Supreme Court case involving a man called, I think, Sutherland. But there's 10 principles or thereabouts which you must be present in order for you to ground a successful, actionable claim for workplace stress. And if you were to summarise the 4 or summarise the 10 things down into 4 things that need to be present. 1, there must be a duty of care. So there must be a duty of care from the employer to you. That's a very, very easy thing to show, very, very easy thing to prove. It's self-evident and it's widely accepted that an employer has a duty of care to an employee. The other 3 things, however, are much less easy to prove. 1 is that you've suffered a recognised injury. You've actually suffered harm, and it's an injury. It's not a condition like you're feeling a bit of stress or you're feeling stressed and you need to take a little break or take some time off. You must have suffered harm, you must have suffered an injury, and the injury must be recognisable. Secondly, the employer must have been or should have been able to, if he or she was not negligent, the injury or harm must have been reasonably foreseeable. If the harm wasn't reasonably foreseeable, if it wasn't foreseeable at all, well then, in those circumstances, it's very unlikely that the employer is going to be held liable or held negligent. And fourthly, you must prove that the harm that you suffered has arisen as a consequence of the workplace stress, the stress in the workplace. In other words, there must be causation between the workplace stress that you claim and the injury that you've suffered. And the injury must be recognizable, and the harm that has occurred was reasonably foreseeable. If those four things are present, then you have a claim that may succeed, but you do need those four things to be present at the very least. And you do need to differentiate between that type of stress and that type of circumstance from the ordinary occupational stress, which courts have found to be perfectly natural and normal and inevitable. So you do need to be able to differentiate, or get legal advice anyway, and differentiate between occupational stress and actionable workplace stress. Actionable workplace stress, by definition, is actionable. You may win, but you can certainly bring a claim for breach of contract and or personal injury and or negligence and or a breach of the health and safety obligations of the employer. But you must differentiate between that and occupational stress, the stress attendant with going to work, with perhaps being involved in a disciplinary process, with making a complaint and having to give evidence perhaps and stand up your complaint and subject yourself to perhaps being questioned about your complaint. That type of stress is what comes with the territory, quite frankly, in the workplace, and you need to differentiate between the two. I hope you find this video useful. If you do, you might give it a thumbs up down below, and if you're not already subscribing to my YouTube channel, you may be interested in subscribing to it. And I want to thank everybody who has supported the channel to date, or people who have liked it and subscribed and shared and made comments and so on and so forth. It gives good old encouragement to me to continue making these videos, which I hope you find useful.